Welcome to Immigration Talk with Attorney Anish. Attorney Anish is an immigration lawyer who has been certified as a specialist in immigration and nationality law by the State Bar of California's Board of Legal Specialization.
Hello, everyone. This is Anish Vashista, and you're listening to Immigration Talk with Attorney Anish. It is May 29th, 2019. Now, people ask me, why do I include the date in these recordings? And the answer is simple. Immigration law changes the law. So the date that you're listening to this is important in relation to when I recorded it. Because if you're listening to this a month from now, a year from now, 10 years from now, the situation with the law might be different, but it might not. So I want people to know that when they're listening to this is important in relation to when I actually recorded it. Today I want to talk about the EB-2 and EB-3 green card processes because I receive a lot of questions about these processes, and they're mostly general questions about what the process is like. And even though there are some resources online that summarize it, I find that releasing this recording could be helpful to a number of people who really don't have any idea as to how it works. The fundamental point that one must understand about the EB-2 and EB-3 process is that the purpose of the foreign national receiving the green card is not a reward for their hard work here in the U.S. The purpose is so that the foreign national can provide his or her labor to the petitioning company. So that's very important to understand. The benefit is for the company. And the foreign national is not required to work for the company during the process. The foreign national is required to work for the company pursuant to the labor certification application and the I-140 upon issuance of the green card to the foreign national. The foreign national must work for the petitioning company upon receiving the green card pursuant to the terms of the labor certification application and the I-140. If not, then there could be some big problems later down the road if there isn't a sufficient reason as to why the labor or services that were promised were not provided. Now, when someone hears the term EB in the immigration law realm, it means employment-based. And when there's a number afterward, that tells you which preference category it is. There's EB-1, EB-2, EB-3, EB-4, and EB-5. EB-2 is in relation to people who have exceptional ability or people who have advanced degrees, which is defined as either having the equivalent of a U.S. bachelor's degree plus 5 years progressive work experience after receiving that degree, or having the equivalent of a U.S. master's degree. EB-3 refers to people who have either the equivalent of a U.S. bachelor's degree or to certain skilled workers who have 2 years of training or experience in a specific field, or to unskilled workers. The processes for these cases is largely the same. In the EB-2 field, there's an exception for people who have pursuing a national interest waiver. We're not going to be discussing that in this recording. But for the most part, the process is the same, other than the differences in relation to what the EB-2 encompasses and what the EB-3 encompasses as far as degree and experience requirements. And I break down the process into 3 phases. There's the Department of Labor phase. That's phase 1. And that itself has 3 subphases, which we'll get to. Then there's the I-140 phase. That's phase 2. That's with the USCIS. And phase 3 is the green card phase. That's also with USCIS, or it could be the immigrant visa phase if the foreign national is not in the United States or is otherwise deciding to process his or her case outside of the United States. So turning to phase 1, the very first step, there's an employer and there's a foreign national prospective employee, maybe a current employee if that foreign national is working for that petitioning company in an H1 on an H1B or an E2 or TN or O1 or whatever non-immigrant category that foreign national has, permitting him or her to work for the petitioning company. Phase 1 is broken down into 3 subphases. The first subphase is the prevailing wage determination request. We need to know how much a U.S. worker for this position would get paid in this geographical location of the United States. So we submit a prevailing wage determination request to the Department of Labor. In it, we have to describe the job sufficiently so the Department of Labor can decide in which category the job fits and what the wage level out of 4 possible wage levels applies. And that will dictate what the prevailing wage is for the full-time green card position. Now, with the prevailing wage determination request, we want to make sure that we're as accurate as possible, because whatever we put into that prevailing wage determination request, if wrong, could come back to bite us at the very end of the process. So we got to make sure that we did everything right in the prevailing wage determination request. The U.S. Department of Labor will take about 4 months, that's what they're taking right now, to issue a determination and say which job category, which wage level, and therefore which prevailing wage. That will allow us, if we haven't already started, to move to subphase 2, which I call recruitment. We have to advertise the position to see if there's a U.S. worker who fulfills the criteria for the job and is willing to take the job. In addition to listing the job in 2 Sunday newspaper ads, there are also a number of other recruitment requirements that apply. And in addition to the state workforce agency posting and the company's website, there are 10 other criteria or 10 other possible ways of doing the recruitment, of which 3 need to be complied with. I'm not going to go through all 10 right now, but one can imagine all the different ways that a job can be advertised. The recruitment has to be posted for at least 30 days, other than the 2 Sunday newspaper ads. And then after the marketing or the advertisement of the position is done and taken down, the petition company has to wait another 30 days to see if there's any responses. If there are responses, then adequacy of the candidate must be evaluated. If the candidate meets the criteria, then that candidate has to be offered the job if they're a U.S. worker. But the company can't simply say that we don't want to hire this person because they didn't interview well, or these other intangible reasons for denial of the job. So that's very important to understand. If there is no suitable candidate, meaning there's no candidate who applies who meets the criteria for the position, then we can move to subphase 3. Subphase 3 is filing the labor certification application, otherwise known as PERM, with the Department of Labor. It can be done electronically. For the most part, it's done electronically, where, again, the job is described, the recruitment is summarized, and the candidate that the job is going to be offered to is listed with that candidate's educational and experience, education and experience listed in the PERM application as well, to show that they meet the criteria for the job. You submit the PERM application, assuming the Department of Labor doesn't pursue an audit, meaning that they want to see the recruitment materials before making a decision. Then the Department of Labor will take about 3 months to certify the PERM application. Once you have a certified PERM application, then the company has 6 months to file the I-140. The priority date is dictated by the date that the PERM application was filed with the Department of Labor. So even if the company waits 5.5 months to file the I-140, the priority date of that I-140 will still be the date that the PERM application was filed with the Department of Labor. So that's good. The I-140 can be pursued, for the most part, with premium processing, and that will allow for a decision within 15 days. If the I-140 is approved, then we can move to phase 3. Before we move to phase 3, we want to make sure that we do everything right in the I-140. We describe the position in a manner consistent with how we did so in the prevailing wage determination request and in the PERM application. We show that the candidate has the educational and experience requirements to fulfill the position as described in the prevailing wage determination request and the PERM application. And most importantly for the I-140, we have to show that the company or the petitioning entity has the ability to pay the prevailing wage. This is a big problem in a lot of cases because it's not seen in the H-1B context. There's no ability to pay requirement for an H-1B, meaning that a company could have negative income and still petition someone for an H-1B. In the I-140 context, that gets very difficult. We need to show that the company has net income that is at or exceeds the prevailing wage, or that the company has net assets, but that for the most part only applies when the petitioner is a sole proprietorship. Or we can also show that the candidate is already receiving the prevailing wage in a position with the company. That's also very helpful in showing that no additional income will be required to pay the candidate because they're already making the prevailing wage. If you can satisfy the I-140 ability to pay requirement, then the I-140 could be approved if all the other requirements are met. And we move to phase 3, which is the green card phase. Now, when someone can apply for the green card, or when someone either in the U.S. through adjustment of status or outside of the U.S. for an immigrant visa, we have to know what the priority date is, and in relation to what priority dates are current. Now, the priority date that is current depends on what country the foreign national was born in. In some cases, if the foreign national spouse was born in a different country, we can use the foreign national spouse's country of birth. This is particularly important for countries such as India and China, which have long lines in the EB-2 and EB-3 categories for priority dates. But if their priority date is current, then the I-485 green card application, if pursuing adjustment of status, can be filed simultaneously with the I-140. Now, some people may want to wait because if the I-140 for whatever reason is denied, then the I-485 green card application, which is wholly dependent on the I-140, could also be denied because now it no longer has anything on which to rely. So some people instead will want to pursue an I-140, possibly with premium processing, wait to see if that gets approved, and then and only then file the I-485. In the consular processing sphere, one could pursue the immigrant visa abroad only if the I-140 is approved. There is no such thing as a concurrent I-140 consular processing scenario. Now, in some cases, we don't have that option. Maybe the person's non-immigrant status is going to expire, and they're going to be out of status, and maybe they don't want that, and they can't wait for the I-140 to be approved. So they take the risk and file the I-140 simultaneously with the I-485. If the I-140 is approved, great. That's wonderful. But just filing the I-485 in and of itself also does not create work authorization. One can simultaneously file for a work permit and a travel document, otherwise known as a employment authorization document and an advance parole, respectively. Once those are issued, then the person has employment authorization. They can also travel internationally and come back to the U.S. while the green card application is pending. But at all times, there needs to be a maintenance of the intention of both the candidate, the foreign national candidate, and the petitioning company for compliance with the prevailing wage determination request, the perm application, and the I-140. If there isn't such intention, then the I-485 could be denied, because the whole basis for the green card process is so that the foreign national can work for the petitioner upon the foreign national's receipt of the green card. It's not a reward for the foreign national for all the hard work they've done. It's a benefit that's given to the petitioning U.S. company who has not been able to find an adequate U.S. worker to fulfill the job and has been permitted to hire a foreigner to work for that company. That's the whole basis of the employment-based second and third preference categories. And that's very important to understand, because if the foreign national does not work for the petitioning employer upon receiving the green card, that could play a huge problem down the road when the foreign national, say, wants to naturalize as a U.S. citizen. So I hope that clarifies the EB-2 and EB-3 processes from beginning to end, and also clarifies the whole basis for why these categories exist and why so much has to be done, because the U.S. government wants to prioritize U.S. workers. However, the U.S. government does not want to punish U.S. companies who cannot find adequate U.S. workers to fulfill the positions. So when pursuing EB-2 or EB-3, for the most part, we must show that there has been a pursuit of a U.S. worker to fulfill the job, but it failed. And therefore, there is a foreign national who can be offered the job because that foreign national meets the requirements for the position. Now, just because someone has an approved I-140 doesn't mean that they're going to get their green card application approved. Similarly, just because you have an approved perm application or certified perm application doesn't mean the I-140 is going to be approved. So, achieving success in one of the early phases does not guarantee success in a later phase. That's very important to understand as well. Anyway, stay tuned for our next podcast, where we'll be discussing a different issue with immigration law. And again, please note the date of the recording, because situations can change. And for people who are listening to these recordings years down the road, and this sometimes happens, I meet people who tell me that they listened to a recording or watched a video that I did several years ago. And so I want people to be aware of the date that this recording was done, Again, it was May 29th, 2019. If you have any additional questions, feel free to reach out to an immigration lawyer to ask additional questions. And for everyone, please stay safe. Thank you.